I call on Government Order of the Day number 4.
Interrupted debate on the second reading of the Parole Amendment Bill.
On the last occasion the House was considering this bill, Carmel Cepoloni was on her feet and she has 6 minutes remaining if she chooses to use it.
Thank you, Mr. Speaker. Mr. Speaker, I was not on the Select Committee considering this bill, but I can see why Labor supports this particular bill. This bill amends the Parole Act 2002 to increase the maximum time between parole hearings from 12 months to 2 years. For offenders serving indeterminate sentences or sentences of 10 or more years, the maximum time between parole hearings increases from 3 to 5 years. Hearings will also be aligned with the completion of core milestones in an inmate's offender plan, and this is estimated to reduce the number of parole hearings by 800 per year. Mr. Speaker, we support this bill, and Mr. Speaker, the one thing we're very aware of is that victims of crime can often feel unnecessary stress dealing with the prospect that their offender may be released each year, when in reality there is little prospect of that. And I think each and every one of us in this House, the general members of the public, have seen on a number of occasions, particularly with high-profile cases where there have been victims who have been traumatised by the fact that on an annual basis, them and their families have had to go through these quite excruciating parole hearings, Mr. Speaker. The justice system must work to support and protect the victims of crime, and by putting them through this unnecessary stress and trauma when there is very little hope of the actual perpetrator of being released, we do agree, Mr. Speaker, that it is unnecessary. Labor's vision is of a New Zealand that guarantees civil and human rights, provides equal and full access to justice, and achieves real public safety rather than just delivering immediate punitive measures. Currently, Mr. Speaker, the Parole Board is required to consider every offender who is eligible for parole at least once every 12 months. Where there is, as I said before, little chance an offender might be released, this does cause unnecessary harm. Well, we must have a fair parole system for offenders who have accepted their actions and are ready to be rehabilitated. Where there are not parole not parole hearings are a waste of time. This bill builds on previous work done by Labor. The Parole Board, as we know it today, comes from the work of Phil Goff, and actually I think this particular bill has been sitting on the order paper for quite some time and could have actually been addressed a lot earlier than what it has been, Mr. Speaker. There does need to be some assurances that suitable candidates for parole are not being detained longer than necessary. Changes at Select Committee with the insertion of Section 21A and B address this though. Select Committee also said, in our consideration of the bill, it became clear that information on civil protection orders was not automatically available to the Parole Board. We see value in the Board having access to information on civil protection orders, which may be relevant to their decision making. We have raised this issue with the Minister of Justice for her consideration. So that was directly from the Select Committee, and we, on this side of the House, are hoping that the Minister will look at that. So there have been changes to the bill made at the Select Committee, at the Select Committee. So by majority, the Law and Order Committee recommended the bill pass with the following amendments. That we replace the term risk milestone with relevant activity, as it is more neutral and does not imply a measure of potential risk. That we insert clause 5A so that standard release conditions applied automatically would be treated as if they were imposed by the Board. And that changing references to the Department of Corrections in clauses 10, 11 and 12 to, quote, the manager of the prison in which the offender is detained, end quote, because it is unclear currently who would be responsible for judging whether an offender has completed the relevant activities. Two additional changes, Mr. Speaker. Clause 10 would insert new Section 21A, which would require the Board to set a date for the next parole hearing when declining parole. It would also allow the next hearing to be brought forward if the offender completed specified relevant activities. And the final change recommended at Select Committee, Mr. Speaker, was amending Section 21A(b) so that when declining parole, the Board could specify completion of a relevant activity as a factor in bringing a parole hearing forward only when the next parole hearing was more than 12 months away. So we do support this bill, Mr. Speaker, and I look forward to hearing the other speeches from the House. Thank you.
Jonathan Young.